let it, just a second, let everything settle down.
All right.
People in and out. All right, we'll hear from the appellant when you're ready.
Thank you. All right, I'll save 4 minutes for rebuttal. Good afternoon, Your Honors. I'm Charles Michaels, representing the town of Nolensville. We are here today on Nolensville's request to overturn the trial court's determination that John Olderman and Christopher Smith, the principals of the counter-defendant CCD Oldsmith Henry LLC, cannot be liable in tort for acts they committed on the LLC's behalf. Nolensville also requests that this court overturn the trial court's decision denying Nolensville's motion to add Olderman and Smith as counter-defendants on the ground that Nolensville can obtain complete relief on the issues raised in the town's counterclaim solely against Oldsmith. The case arises out of Oldsmith's request to rezone approximately 174.7 acres of real property in Nolensville. Oldsmith could build 105 homes as the property was originally zoned and was requesting under the new zoning to build 251 homes. The town had significant concerns about the project's impact on a nearby intersection that would already required a new traffic signal. At second reading of the request for rezoning approval, which was final reading, the town engineer said that the town could not approve the rezoning based off of the need for the traffic light, but that the Tennessee Department of Transportation was looking into funding the project. Oldsmith spokesperson at the meeting, Christopher Smith, advised the board that Oldsmith, as a property owner, can do some things that are over and above what a traffic study required, and the traffic study showed that Oldsmith would contribute 12% of the traffic at the intersection. Smith ended up stating that whatever TDOT contributes to the traffic lights, Oldsmith will contribute the difference. Nolensville approved Oldsmith's rezoning request conditioned upon Oldsmith paying up to 50% of the cost of the traffic light at either 50% occupancy of the homes in the development or at the time when TDOT commenced construction of the traffic signal. During the meeting, Mr. Smith clearly acknowledged Oldsmith's understanding of these terms, as Mr. Smith agreed that based off the estimated cost of the light in 2019, which was $575,000, that Oldsmith would pay $283,000. I'll fast forward to 2023, and the price of the traffic light had increased substantially.
Weren't specific dollars amount discussed at the hearing on the permit when Mr. Smith and representatives of the town of Nolensville were discussing the permit?
That was the $575,000. There's some additional commentary that Nolensville had a special traffic light that may add $100,000 to the cost. And then there's discussion that one half of that would be, again, approximately the $283,000 plus half of the special light cost.
But your position is there was no guarantee that it wouldn't exceed a certain amount, and of course now the question is whether the members of the LLC are responsible.
Correct. There was discussion at the meeting as to whether Oldsmith should pay that amount up front, which would have then been something around $300,000, or wait until further along in the project. And my recollection, as I sit here today without looking at the transcript, is that Mr. Smith preferred paying the money somewhere down the line as opposed to up front. Now, granted, in hindsight, it would have been nice if they put a significant number on there to be paid at a specific date, but hindsight's 2020. So again,
Well, let me ask you just a couple of basic questions here. What are you allege negligent or fraudulent misrepresentation?
yes.
Is that correct? What are the elements of those two?
The elements of intentional misrepresentation are that, that there has to be a misrepresentation of an existing or past fact.
All right, let's just focus on that. What was the you claim was the misrepresentation of what was the existing or past fact that was misrepresented?
At the time, Mr. Smith stated that Oldsmith would pay whatever TDOT didn't contribute to the light. That was before the town conditioned it on up to 50%. But then later on, when Oldsmith filed suit because the town was withholding building permits, John Olderman, who was also in attendance at the meeting, said that Oldsmith never intended to pay for more than 12% of the lights, and then there's argument presented in the briefs in this case, for example, that states that what Christopher Smith intended was that Oldsmith would pay some portion of the traffic light, some proportional amount, as opposed to paying up to 50%.
So are you arguing that the existing or past fact was a statement as to what they intended to pay in the future?
Correct, which can be the basis so long as it's established that there was never an intent to perform the future promise, which is where the Olderman affidavit comes in saying that they never intended to pay more than 12%, and where the statements in the briefs that what Mr. Smith was trying to say was that they would only pay some proportion of the traffic lights as opposed to up to 50%. Back to the trial court's actual ruling. The trial court's focus was on whether the agents of an LLC can be liable for their own misrepresentations. Clearly, the law is that when a member of an LLC acts, that member can be individually liable for his own acts. It's not just that the LLC is liable. I mean, that's set forth in TCA 48, 249, 114A2. It states a member of an LLC may be personally liable by reason of such person's own acts or omissions. And again,
Which brings me to another question.
yes.
What did you or your client allege that, is it Olderman, the other individual? Is that his name?
Olderman is the other individual, yes.
Yeah, what did your client allege that he misrepresented?
He was at the meeting, and it would be an omission because he never, I guess, clarified Mr. Smith's statement that Oldsmith was going to pay.
So it would be a misrepresentation by omission because another member of the LLC said something.
He was there, well, he was also there on behalf of,
I understand he
The
was
LLC.
there, but did
Yes.
he say anything?
no, that's exactly why he'd be liable for his omission. And then,
Usually an omission exists when somebody makes a representation but doesn't include a fact. Here, you're saying mere silence is constituting an act of omission. I'm having a little trouble processing that.
I guess when you get down to it, I mean, you could still look to the fact that now Christopher Smith, I mean, it's not in an affidavit or anywhere like that, but it's in the pleadings, was saying that what he meant was that he was only going to pay, Oldsmith was only going to pay some proportionate amount, not up to 50%. So there's a separate argument beyond the omission by Olderman that Mr. Smith is also, at least as conveyed in the briefs.
And Mr. Smith was the one who was speaking
He was the one who was
on behalf
speaking.
of the LLC.
And there were times in the transcript when Mr. Olderman does speak up and throw in comments. Again, he could have certainly interjected and said, that's not what we're going to do. And then the other issue in the case would just be the denial of the motion for joinder on the ground that complete relief could be granted in the absence of Olderman and Smith. I would submit that when we're talking about Rule 13.8 and Rule 20, it's looking to complete relief on the claim that the counter plaintiff is making, as opposed to what Rule 19 requires, which is complete relief amongst the parties in the case. Nolensville can't obtain complete relief on its claim, which is joint and several liability between the members of the LLC and the LLC itself, absent having those members of the LLC in the suit. So again, Nolensville claims that that was also an error by the trial court. And also just going back to what Mr. Smith did that would involve misrepresentation. There's the Noblin v. Christensen case from 2007 that states that in order to establish that a promise was made with no intent to perform, the best gauge short of an admission is to examine actions, and such intent can be established through conduct or other circumstantial evidence. And the issue of whether the intent to not comply with a promise is a question of fact. So I would still submit that it would be inappropriate at what was essentially the motion to dismiss stage to determine that Mr. Smith had a present intent to pay the 50% when Oldsmith never paid the 50%, despite Mr. Smith clearly being held out as the representative of Oldsmith. And he now says that they were only seeking to pay a proportional amount. Thank you.
You have your time for rebuttal. Yeah, thank you. We'll hear from the appellee.
Please the court, Tom White of the Nashville Bar Law Firm of Toon Hettrick and White. I represent the appellees in this matter. I would respectfully submit the background in this case is that my client, as a builder developer, intended to do a residential development in the city of Nolensville. They came forward with a proposal to take it from basically an upgrade in residential zoning and a planned unit development, which is an overlay on top. That was the request. There's no dispute that there was a light at the intersection of York and Williams Road along with Nolensville Road that was clearly deficient at the time. There's a lot of discussion when this matter came up in front of the legislative body about what should be done here. And the appellant in this case continues to single out one comment by Christopher Smith, which says what TDOT does will pick up the difference. That singular comment comes through about an hour and a half of dialogue where repeatedly the comments are made, we'll pay our proportionate share. It's over and over. There's comments by members of the legislative body which make the comments that it ought to be proportionate, shouldn't all be on these folks, et cetera. And as Judge Clement talked, there were discussions about numbers. The numbers at the time were approximately $585,000, and there was a discussion about a $238,000 commitment perhaps by my client. Discussions about the numbers, no commitments, no caps, but the discussions were there. Based upon that difference, the client moved forward, and at some point, many months later, the city sent a letter to my client demanding the sum of $688,000, almost 3 times the numbers that were discussed when the property was rezoned. The client received that. I became involved. We looked at the request. We declined to pay the money that the city had demanded. At that point, the city, I think, made a very unfortunate decision. It just said, well, quit issuing building permits till you pay the money. Clearly unlawful, inappropriate. I filed a lawsuit and an injunction to require the city to issue the building permits. That was granted by Judge Johnson in this case. And she basically talked about the high-handed or bad faith comment by the city of Nolensville, basically said correctly it was basically extortion to require them to do that. They then went forward, they issued the building permits, but again, the comments made at that hearing at the legislative body that they talk about was one sentence out of an hour and a half of dialogue where many of the governing body made the comments it wasn't fair to put everything on my client, et cetera. So after the injunction was granted and building permits were issued, we came forward in this case and a counterclaim was filed by the city of Nolensville and also a request to join in these 2 individuals, Chuck Olderman and Christopher Smith, individually. I respectfully submit to this court, I think the real issue here is whether there was an abuse of discretion by the trial judge under 13.8 about not including these 2 individuals. And I know the court is very conversant with the language in 13.8, but the language which was relied on and clearly was not an abuse of discretion by the trial judge says as follows. When the presence of parties other than those to the original action is required for the granting of complete relief in the determination of a counterclaim or cross-claim, the court may order them to be brought in as defendants as provided in these rules. So I respectfully submit there's two predicates under 13.8. Number one, it's got to be required for complete relief. Number two, it's a discretionary call by the trial court. The cases talk about that being a decision at the trial level because they have judicial discretion. They talk about managing the case, how it moves forward. So in this case, what was the ultimate claim? The claim was that the applicant, which is the LLC here, the LLC was supposed to pay certain money. Where in the record is there anything that reflects that the LLC is not able to pay the money? It doesn't exist. So with respect to the burden of can complete relief be granted without the inclusion, it's absolutely clear that it can. The claim's a money claim. It was a money claim asserted against the LLC. And again, there's nothing in the record that indicates they can't include that. Now, with respect to the comment made by counsel about Rule 20.
Who has the burden on that? Showing whether there is or isn't, whether complete relief can or can't be obtained.
Judge, I think respectfully that would be on my client.
So what proof did your client put on to show that the LLC is going to have plenty of money to pay it? You don't have to worry about trying to collect it from an individual.
That never came up. We never put on that proof, Judge. I mean,
All right, so there's no proof there showing that complete relief can be obtained by judgment against the LLC.
I think the only thing I can comment there is that it's a claim by the city of Nolensville against the LLC, and there's nothing in the record that indicates they couldn't pay it. So it would seem to me that although I think facially that burden may be on me, it's also a responsibility of the town in this case to show that we filed it against the LLC, we can't claim it against the LLC, and there's no assertion, there's not even an assertion that they can't collect it against the LLC. So I respectfully submit that in this case the trial court looked at it, and I think that's really the governing issue. Was there an abuse of discretion by the trial judge? Now that burden is clearly on my opponent in this case to show that.
What did the trial court have before it showing that complete relief could be obtained by a judgment against the LLC?
They had a complaint filed against the LLC to seek the money. There was nothing that showed anything any differently than
Well,
that.
my question to you is, what did the trial court have before it showing that complete relief could, you said burdens on your client. So what did the trial court have before it showing that complete relief could be obtained just by a judgment against your client?
I can just say the apparent claim by the city against the LLC and the lack of an assertion by the city that they couldn't collect it. I mean, to me, it would seem you would come in as my adversary in this case and say, we need to add these people because the LLC doesn't have the ability to pay. That was never asserted. There's bonds up for these obligations, and I think in this case, it was relatively clear that my client was a significant developer. The LLC had a significant project out here, which was a massive project in Nolensville. There was no reason for anybody to expect that the LLC would not be able to fund it. That's my comment, Judge. But again, if you talked about was there some assertion there, I think the burden at the trial court when the opponent wanted to assert that these people should be added individually would be to show basically here's an LLC, they may not have the money to pay. It was never even mentioned. It never mentioned.
Okay.
The other thing, I'll comment really about the tortious conduct and other matters. I respectfully think most of that is basically dicta in this case. I really think it's the 13.8 and the, quote, alleged abuse of discretion. The burden and the scope of review here is, did the trial court abuse the discretion by refusing to include these parties? And again, I think it's relatively clear that on the face of everything, that complete relief could be granted without adding. And then I'll comment that at all the public hearings which are recited here, there's always a reference that my clients were there as representatives of the LLC. There was never any actions that were outside of the parameter, outside of the venue of them acting for the LLC. And that's been repeated. Again, as my counsel on the other side commented, he said these are statements by the LLC. Nobody ever showed up individually. But with respect to what I think may be dicta, when you have to have fraudulent or conduct that's outside the LLC purview, they always identify themselves as representatives of the LLC. Secondly, with respect to a misrepresentation of a past or a present conduct, it's not there. They were making comments about what they thought might be the appropriate contribution for this light. All the authority, not that that's particularly controlling here, showed that they were a 12% factor. And when my adversary makes the comment that Christopher Smith made the comment, "We'll pay the difference," what happened after an hour and a half of dialogue? They moved approval that my client would pay no more than 50%. If it's as clear as what they're saying it should be based on that one statement, they would have said, well, you're paying everything other than what TDOT pays here. That wasn't the case. After an hour and a half of dialogue, they made the comment, which is clearly reflected in the record, that they would absolutely be required to pay no more than 50%. That's pretty clear. Less than 50%. Not whatever TDOT doesn't pay, we will, as a result of all the comments that took place. So I'd respectfully submit that, number one, the comments made by my client at the hearing were clearly under the ambit of the LLC. Number two, with respect to the comments they made, they were not a misrepresentation, period. They certainly were not a misrepresentation of past or present fact.
Let me ask you about the first part of that. So is your position that if a member of the LLC stands up and makes, I'm understand, just assume for this, that the question is that, so I understand it was not a misrepresentation, but that if a member of an LLC stands up and makes a misrepresentation or says it, sends it in a letter, whatever, makes that misrepresentation, that the individual member can't be liable for his fraudulent act?
I'm not saying that. I'm saying the opposite. They clearly can be. If they make a misstatement or a fraudulent comment, whether they're under the umbrella of the LLC or not, that's what brings it over individual liability.
Okay, well, isn't that what they're alleging here? I know you're saying that Smith didn't make, or either one of them made no fraudulent or misrepresentation, but aren't they alleging that they did so that they are individually liable and the LLC is liable? That's their allegations, isn't it?
I admit that's their allegation.
Okay.
There's no basis in fact for it, but that's their allegation. Because as the court's already commented, there's got a fraudulent or misrepresentation of a current or a past incident. It's not there. They were talking about what might be paid in the future about a light configuration. That hardly crosses the Rubicon with respect to the issue of fraudulent or misrepresentation of a past or a current fact. It's not there.
What do you say to his argument, your opposing counsel's argument, that, well, the existing fact that they misrepresented was that they intended to pay the difference, or they intended to pay 50%, whatever, that he says that's the existing fact they misrepresented as to what their intention was, or the LLC's intention was at that time. Does that qualify as an existing fact?
I certainly don't think so. I mean, it's a subjective conclusion by them about what somebody was thinking at the time. You know, the misrepresentation is relatively clear under Tennessee law of what's currently known or past known facts, which are basically misrepresented. That's not the case here. And I'd respectfully submit, I understand their argument, and I don't disagree with the law that you asked me about, that if you reach outside of that LLC umbrella with a misrepresentation or a fraudulent comment about a future fact, then clearly that's the grounds for a shredding of the liability under the LLC. I don't disagree with that. But with respect to the issue that's here, again, if we look at 13.8, the key issue, in my opinion, is whether there was an abuse of discretion by the trial judge. And again, the front end issue is, could you have complete relief without the inclusion? I think it's relatively clear you can. And secondly, it says may. It's a decision by the trial court. I think there was sound discretion here, should be done in accord with that. And the background here, I think, is relatively clear that the town of Nolensville had overreached on a number of different things. And in this particular case, making an assertion that two individuals should be included. The first position by the city of Nolensville, ironically, was that when we were going to submit the affidavit by Mr. Alderman, they said he wasn't even at the hearing. They weren't even aware he was there. He was sitting right there. They took the position he wasn't there. He was there. He did make the comments that he did. But again, I respectfully submit that there's no misrepresentation of a then fact or a past fact that would, in my opinion, basically bring it into the individual liability. So I respectfully submit to the court that there's nothing in the record, in my opinion, that would indicate that complete relief could not be granted. On the face of it, there's no reason to look at it and say, gosh, well, maybe we could consider the LLC, maybe they don't have the money. It wasn't even raised. It wasn't even raised. wasn't raised in trial court, wasn't raised in the brief. And so I respectfully submit to the court that even under Rule 20, which they try to argue here, the language under 20 says may. Doesn't say just because you might assert a common theory that has facts and law in common, you include them. It says may. You go back to 13.8, which says complete relief can be granted without them, and number 2, it's a discretion of the trial court. And it's basically done on an abuse of discretion basis by the trial court in controlling the litigation and making some position about where the matter stands going forward. And I respectfully submit that the trial court opinion here should be affirmed, and I appreciate your courtesies today. Thank you.
Thank you. We'll hear from the appellant rebuttal.
Thank you. I first want to address the comments regarding extortion and the building permits. It was pointed out during the hearing on the motion to enjoin the town that Christopher Smith, during the hearing in which the rezoning got approved, he stated that if Oldsmith didn't pay, then the town could withhold building permits. When that was brought up to the trial court, the trial judge at the hearing said that that statement lacks context. For all I know, he was joking. So regardless of what the trial court did on the building permits, with there being a transcript, I really think the context of what Chris Smith was saying could have been ascertained. And regarding the
How can a representative of a disclosed principal, an agent of a disclosed principal, a member of an LLC, be held accountable for fraud or intentional misrepresentation when the amount of the obligation was uncertain at the time the statement was made?
Well, in this case, for example, there's discussion of paying the $283,000. I believe in Oldsmith's complaint, they say what they owe is something less than $100,000 or something like that. So there is discussion about real numbers, and they're saying they owe less than that. And at the end of the day, if they were only going to pay 12% and they never intended to pay up to 50%, then the answer is we're going to pay our proportional 12%. You don't tell the town we're going to pay whatever TDOT doesn't pay. You don't interject when they say we're going to pay up to 50%. And regarding the up to 50%, that was actually included because there were some other developments that they'd already been approved, but the town was going to go back and see if they'd pay any extra money. And one development, I believe it was Summerlin, had contributed $30,000 or something like that. So that's where the up to 50% language came from. And again, I think the court has caught on to this, but there are two distinct issues on the standard of review. Clearly, it's abuse of discretion on the joinder issue, but it has to be de novo on the issue of whether Smith and Olderman can be liable, because essentially what the trial court did is said, not only can you not join them, you can't go back and sue them separately because they can't be liable because they're members of an LLC. I mean, respectfully, the case law is clear that members of an LLC can be liable if they commit negligent or intentional acts while acting for the LLC. And regarding Rule 13.08, Tennessee Supreme Court in Gaston v. State references an Illinois decision which discusses that joinder is proper when a plaintiff seeks to hold a corporate officer jointly and severably liable for an act committed on the corporation's behalf, which is exactly what Nolensville seeks to do in this case. The issue with the trial court's decision here is that it has to be an abuse of discretion, because the only basis for her ruling that appears is that they can't be joined because they can't be liable because they were acting as members of the LLC, which, again, isn't correct. The trial court didn't discuss the fact that it's the exact same claim against all of them, or that you just have to file a separate suit, so on. Thank you.
Thank you. We appreciate both counsel's arguments today and your briefs on this.